missing any? Nope. All right, we'll go back on the record on State versus Rosario. Mr. Rosario and his attorneys are present. The State Attorney's Office is present. Mr. Rosario is dressed in civilian clothes as discussed this morning, and his shackles cannot be seen. All right. Everybody ready for closing, State?
We are done.
Defense? Anything else we need to discuss before I bring the jury back in?
No, you're.
All right, let's bring them. State recognized presence of the jury.
We do, Your Honor.
Defense?
Yes, Your Honor.
All right, welcome back, folks. Hope you had a good lunch. Anybody see, hear, or read anything about this case during lunch? Anybody attempt to talk to any of you about this during lunch? We're at the stage, both sides have now rested, so we're going to do closing arguments. But first, as I told you, I'm going to read you part of the jury instructions. I will stop when we reach an instruction that's numbered 3.10, and then I'll read one that you don't have. The attorneys will then do their closings, and then I'll read the rest of the instructions to you. We do it that way so that you have the law and the elements before you, before the attorneys do closings. The deputies are going to pass out some jury instructions for you all, or did you already do it?
No.
Oh, go ahead. Thanks. Everybody got one? All right. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Juan Rosario, the defendant in this case, has been accused of the crimes of murder in the first degree and arson of an occupied structure. In this case, Juan Rosario is accused of murder in the first degree. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. A killing that is excusable is lawful. If you find Elena Ortega was killed by Juan Rosario, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the first degree or was murder in the second degree or manslaughter, or whether the killing was excusable. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Juan Rosario may be found guilty of murder in the first degree or any lesser included crime. There are two ways in which a person may be convicted of first-degree murder. One is known as premeditated murder, and the other is known as felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Elena Ortega is dead. 2, the death was caused by the criminal act of Juan Rosario. 3, there was a premeditated killing of Elena Ortega. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. 1, Elena Ortega is dead. 2, while engaged in the commission of a burglary, Juan Rosario caused the death of Elena Ortega. 3, Juan Rosario was the person who actually killed Elena Ortega. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. To prove the crime of burglary, the state must prove the following two elements beyond a reasonable doubt. 1, Juan Rosario entered a structure owned by or in the possession of Elena Ortega. 2, at the time of entering the structure, Juan Rosario had the intent to commit theft in that structure. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Proof of possession by an accused of property recently stolen by means of a burglary, unless satisfactorily explained, may justify a conviction of burglary if the circumstances of the burglary and of the possession of the stolen property convince you beyond a reasonable doubt that the defendant committed the burglary. You may infer that Juan Rosario had the intent to commit a crime inside a structure if the entering of the structure was done stealthily and without the consent of the owner or occupant. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Elena Ortega is dead. 2, the death was caused by the criminal act of Juan Rosario. 3, there was an unlawful killing of Elena Ortega by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Elena Ortega is dead. 2, Juan Rosario intentionally committed an act or acts that caused the death of Elena Ortega. The defendant cannot be guilty of manslaughter by committing a merely negligent act or if the killing was excusable homicide. Negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any lawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had the intent to cause death, only an intent to commit an act that was not merely negligent or excusable and which caused death. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard of the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. Dangerous weapon is any weapon that, taking into account the manner in which it was used, is likely to produce death or great bodily harm. To prove the crime of arson, the state must prove the following two elements beyond a reasonable doubt. 1, Juan Rosario willfully and unlawfully caused a fire. 2, a structure that Juan Rosario knew or had reasonable grounds to believe would be occupied by a human being at the time of the fire was damaged by the fire. In order to convict the defendant of arson, it is not necessary for the state to prove he intended to damage the structure. Willfully means intentionally, knowingly, and purposely. Unlawfully means without a legitimate lawful purpose. Structure means any building of any kind or any enclosed area with a roof over it. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of arson of an occupied structure of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of arson of an occupied structure are arson of a structure and criminal mischief. To prove the crime of arson of a structure, the state must prove the following two elements beyond a reasonable doubt. 1, Juan Rosario willfully and unlawfully caused a fire. 2, a structure owned by the defendant or another was damaged by the fire. In order to convict the defendant of arson of a structure, it is not necessary for the state to prove he intended to damage the structure. Willfully means intentionally, knowingly, and purposely. Unlawfully means without legitimate lawful purpose. Structure means any building of any kind or any enclosed area with a roof over it. To prove the crime of criminal mischief, the state must prove the following three elements beyond a reasonable doubt. 1, Juan Rosario injured or damaged real or personal property. 2, the property injured or damaged belonged to Elena Ortega. 3, the injury or damage was done willfully and maliciously. Willfully means intentionally, knowingly, and purposely. Maliciously means wrongfully, intentionally, without legal justification or excuse, and with the knowledge that injury or damage will or may be caused to another person or the property of another person. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did a witness at some other time make a statement that is inconsistent with the testimony they gave in court? 9, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or has been promised immunity from prosecution, or who hopes to gain a more favorable treatment in their own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider their testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Williams, you may proceed.